Yes, and I'm really, really glad to be here. A little bit about my background. So, my name is German, I'm German, but I live in Finland and I speak Finnish. And I don't speak Swedish, and I'm really sorry about this. I know it's much easier, and maybe it was the wrong choice when what should I learn, Finnish or Swedish? I decided Finnish. Okay. But that also means when I introduce the speakers, and I'll do so one by one, I might butcher a little bit the names because I don't speak Swedish. Our topic is the roles in data protection, and from the introduction of Daniel, also the first case he mentioned, Fashion ID, is actually right in the middle of this problem issue of this, what the panel is concerned. Like, what are the roles of the parties if you set a like button? Similar case, Wirtschaftsakademie, almost a year earlier. What if you have a fan page? How is the relationship then with Facebook? And there were other cases in between, the Jehovah's Witnesses case. How we're going to do is we're going to ask first what guidance is available for you, because I assume everyone in the room knows well what the controller, what the processor, what the joint controller is. What guidance is available? That's our first question, and then we'll go a little bit through the case law, and I ask a few questions to the panel, and finally at the end we'll see what practical tips for you, the audience, does the panel have. As our first speaker on the panel, I'd like to introduce Elizabeth Gilderit on the stage. Elizabeth, could you please come up? Thank you. Elizabeth is a senior legal advisor and international coordinator at the Swedish Data Protection Authority and has long experience from working with data protection in supervisory role and cooperation in the EU. She's here to tell us a little bit about what happens at the European Data Protection Board, because guidelines are being prepared. Guidelines we've all been waiting very long for, and Elizabeth is representing the Swedish DPA as lead rapporteur for the current work. So what's coming, Elizabeth?
What's coming? Well, we have hopefully a helpful and interesting guidance coming up. As you all know, the EDPB, the European Data Protection Board's predecessor, the Article 29 Working Party, developed guidance on the controller processor concepts in 2010. And that guidance was obviously based on the previous directive. So what we're doing now within the EDPB is to review this guidance to see what we have to perhaps change or update, considering that we now have the GDPR and the rules there. So this is something that we, the Swedish DPA, took on the role as lead rapporteur for, because we know that this is a very important and essential topic. And we have a number of other countries with us to help us in this work.
That's great. So is there any way one could participate in shaping those guidelines?
It is. We started out with having a stakeholders event in March this year in Brussels. Invited to this event was a number of European business organizations from different sectors. And the aim of this was, of course, to gather as much input and questions and comments as we could before starting this work. So now we're working with the guidance. We hope to adopt it by the end of this year. And after that, as Daniel explained before, in line with all the other guidance, we'll have a public consultation where everyone is able to give comments on the guidance.
Yeah. I'm sure there's going to be a lot of comments on that one.
Yes.
Maybe also comments from the National Organization for Data Protection for the 21 county administrative boards in Sweden, which Mikael Norberg represents. Mikael, please come to stage. He works as a deputy DPO there. So in terms of when you determine the roles, what guidance do you take into account?
Well, we use several kind of them, of course, but one special thing that I would like to talk about is the difference between joint control and the processor and control relation. The Swedish county administrative boards, we share about up to 300 IT systems with other authorities, with the major state agencies in Sweden and the 291 municipalities. It could be information bases, and it could also be systems for handling application processing and such things. And I think it's a common conception here that it's an overuse of the relation between processors and controllers, and proposals for, so to say, signing processor agreements. And I have lost count about how many such proposals we have dismissed since May last year, because it's not the question about a processor and controller relation.
But when you say it's not, where do you base that on? Just the law, or do you take the 2010 guidance available from the...
Because when we have built this IT systems that we have done this together, and we both determine the purposes and means for these systems. So quite obviously, it's very often a question about the joint controls. But up till this day, I think only one authority has approached us having a proposal to, should we make this clear out, this joint control in the so-called, what was the term in the Article 21, I think is, 28 is a written arrangement to make the responsibilities clear. So we're really looking forward to guidance on joint control, actually.
I actually would like to ask this also from Anna Pullio, who's another panelist here and coming now to stage, currently head of privacy at Chanel. She has been at a lot of different roles in-house in privacy, and is also part of a GDPR multi-stakeholder expert group advising the European Commission on implementation of the GDPR. As this work in the multi-stakeholder expert group, where you represented Business Europe, Anna, did the joint controllership that Michael was mentioning, did this come up a lot, or not at all?
It has come up a lot, because I don't think we were speaking so much about joint controllerships or now. And I think that's what Fashion ID has changed recently, because people were trying to look at the relationship between controllers and processors from a static perspective. So every time there was a contract, one was trying to identify themselves as the controller and the other one like the processor. And they were looking perhaps the overall relationship and trying to determine just a single role. So I'm the controller, you are the processor, or we are both controllers somehow. Now we see that there's a part that can be controller to processor, and one part of the processing, which is subsequent or coming before, that could be different, could be two controllers together. So we look at it from a very different perspective. Now, the GDPR multi-stakeholder, for those that are not familiar with it, is a forum set up by the European Commission with 27 advisors representing civil society, the academic community, law firms, but also companies. I represent Business Europe. It's a 3-year term, and Business Europe is basically the lobbying party arm of the national industrial associations in Europe. So pretty much the Swedish is there, and the Germans like BDI, MEDEF in France, and so on. And we've had extensive discussions about liability. So we are all bringing remarks there, and the remarks are that there are sometimes adhesion contracts, so somebody just serves you with a contract and you take it or leave it, otherwise you don't have a contract with them. You could argue that there's like freedom perhaps to choose somebody else, but there are some providers out there that could be even tiny companies, so theoretically the weakest party, but they have such technology and they use it exclusively. So you would have to have a contract with them. And the way they view it sometimes, oftentimes it's perhaps some US startup, not familiar with privacy, and all they say is, I limit my liability, my contract with you is, I don't know, 30,000 euros a year, so that's my cap, 30,000 euros a year. So we looked at that about a year ago, actually, at the GDPR multi-stakeholder, and I think a lot of people felt perhaps a little bit awkward to re-examine the contracts with their providers. But as we're moving along and they're seeing the difficulty coming from these situations, they are more open in discussing them. And what we said at the GDPR multi-stakeholder is that perhaps we should come up with more standardized rules around what is a controller, what is a processor. And
sorry to interrupt there. When you say
Yes.
we should come up, would that be the,
The group-
Commission or
the
would
group-
that be Business Europe?
that group perhaps with some suggestions, but then the Commission themselves wanted to come up with clearer guidance following those remarks. And they even discussed about the potential for some standardization. Kind of like the model clauses. Okay, you shouldn't be scared because they understand.
Well, that's how I make my money as an external advisor. So
Well,
I'm a little bit scared. So.
No, but I think they understand the fact that people have signed contracts to a great extent, but not as much as everybody hopes. You know it, that except when you are a very big player and you can impose terms, it's almost impossible to sign all those contracts with privacy clauses. So being aware of that, they are not in favor of interfering and standardizing everything and coming up with this is the model clauses and you circulate them. But they said maybe we should consider standardizing some aspects of this relationship so that we don't see abuses and so that we better protect data of citizens.
That makes sense. So actually, in my role at Bird & Bird, I see a lot, and the field is very diverse. So some companies will never sign anything until there's like full liability, and there's very long negotiation about this one, and then carves out, and then some others it's basically 12 months of the contract or so, and then it might end up with something with 25 or 50,000 euros. It's very diverse field still, and I'm sure a lot of people would appreciate some standardization. Might be tough with freedom of contract, but it might be a model that people can choose. It might be an optional model or something. Michaela, I think I don't need to introduce you. You have been introduced last but not least on our panel. How is it at Telia company? How do those role discussions in a way work out with vendors, suppliers, partners?
No, but I think Anna put it really well. I think it's a one aspect is the competitive advantage that we see that some players have, and it is really, here you go, this is the agreement, take it or leave it, and there's no negotiations whatsoever. One of the things I do think it would be great to get more guidance. I wonder if it might be some conflicting guidance, if both the Commission and the EDPB will come out with something, but I think definitely as companies that have a lot of these relationships, we need more assistance. The amount of time that my team spent on these negotiations and sourcing lawyers spend on these negotiations, it is really energy draining and not resource efficient because we want to spend time on actually doing other smarter things when it comes to privacy. One thing I'm a bit worried about is that very often in these contracts, it is also, like Anna said, it's not a one-on-one situation, but also like Mikael said, it might not even be that it's a joint controllership because it comes back to who is really determining the purpose and means for each of the purposes in the contract. Yes, exactly. And that means that you can't just say, oh, company A, you're the processor, company B, you're the controller. You need to break it down to much more granularity in regard to the purposes. And then it might be, okay, for these purposes, you're the controller. For these purposes, we're the controller. For these purposes, it's a joint controllership. And that, I have to say, there is a lot more education of our counterparties. That is where we're spending a lot of time today.
No, I can imagine, and I think that's also the main takeaway from the recent case law from the Fashion ID. When the Advocate General published the opinion, I think everyone was a little bit worried, or at least I was. And in a way, I don't know if he used the term, but the slippery slope by saying like, okay, actually they have to be joint controllers, but if I believe that, who isn't a joint controller then? So where is the limit? And then the court basically said, well, you have exactly like Michaela said, like you have to look like one by one. Now this case law in Fashion ID, but I said is those three cases: Wirtschaftsakademie, the Jehovan Todistajat, so actually a case brought from Finland, also from the Nordics, and then Fashion ID from Germany. These three cases, have they changed a lot, Elizabeth? If you see, do you see this in the agency that people ask you and say like, what am I now?
No, I can't say that we've had all that many questions yet. But what I think they've done is they have clarified and emphasized the state of joint controllership. I don't think that before with the directive we looked at people as one controller, one processor. Partly because of the GDPR itself, there's a whole new rule on joint controllership. If you are joint controllers, you have to have an agreement where you divide and lay down the different responsibilities. So already with the GDPR, the joint controllership has come into focus a lot more, and the recent case law just established that even further.
I remember from I was in-house before with Nokia and Microsoft, and at Nokia I dealt with people like Mikael actually on the what we called operator. I'm not sure if that's the current term, but I mean, and some really wanted to be processors. That was kind of like, we're processors. And then some really wanted to be a controller. We're not just a data pipe. We're not just a data pipe. We're a controller. We own the relationship. And so it was really unclear, and was the guidance wasn't that clear. The ones we had the 2010 opinion, and everyone was like clinging to this, and to the examples at the end. But then everyone made, and I heard this a little bit from Mikael also, everyone like kind of looked at the law and interpreted that and made internal guidelines and so on, and worked with that. Once those cases came, and I want to open this question, did you change your guidance on this is now how Telia is doing it, or this is how you do it in your companies or organizations? Did you change the guidance for joint controllership?
Maybe I should answer that because I've looked at it from perspective of companies that were traditional processors to companies that are traditional controllers and those that are a mix. I think there was a big divide before the GDPR and after, because before the GDPR there were reasons to argue you are a processor perhaps because you wanted to just pass on the liability somewhere else maybe. And that's where we saw perhaps some big companies coming in and self-defining themselves as processors when in fact perhaps they weren't and they aren't. Ultimately, that's the point where things started changing because you see that there's more of a balancing. It doesn't matter anymore if you're a processor or a controller. Okay, there are some differences. But again, both could be pulled into liability. So apart from that divide, I think ultimately it doesn't matter what you set up in the contract if you say you're the processor or you're the controller, and then in reality, it appears in the processing of data that maybe you said you're the processor, but in reality you actually determine the means and the purposes of the processing.
2810 actually.
Exactly.
That, yes,
Exactly. So maybe that's a solution that you get granular. And I would say from a company lawyer perspective, I would always try to determine the roles very explicitly, because oftentimes people want to say we are the processor and therefore our liability is limited there, and they try contractually perhaps to limit themselves somewhere. But if they actually become joint controllers somewhere subsequently in the processing, it's better that it is stated clearly in the contract. And we are in a situation where things are not going to be so clear-cut if there's a class action, I think, by data subjects, and they choose one of the parties, and then there is some perhaps liability within the let's call it a community of controllers and processors. That could be a lot, actually.
If I may add on, I think there wasn't, the change didn't come due to the guidelines, the change exactly came due to GDPR, but then it became about the granularity and rather understanding that it's not one or the other. But then I think on again what Anna is saying, I think it's fantastic we get more guidance, but I do think that we also need to start seeing how the data protection authorities will enforce this, to understand how they will break down this regardless of what is stated in the contracts. Will it be so that they actually scrutinize on a detailed level who is the deciding party here? Is it a joint controllership? Is it the whatever it might be? And learning and seeing how that is being dealt with in case law, I think that will be absolutely crucial to understand how to deal with this in a better way for all stakeholders.
In case law, maybe if I'm allowed to say something, because the DPAs, of course, we are at the beginning of the GDPR implementation, and the guidance from the European Data Protection Board is highly appreciated. But there's as much as the regulators can do as well. If we look at the amount of complaints they have and issues they have, they can't be in every
There's a lot to
contract.
choose
and
from.
Can't, exactly. So I think a lot will come from case law when citizens become a little bit, and civil society becomes a lot more sensitive, and so class actions start coming, and then we see really the courts, as we saw in Fashion ID, coming up with certain aspects that would be clear, plus the guidelines that is soft law at the end of the day. So I think maybe in 5 years from now, we're going to be, well, not maybe, surely, we're going to be in a completely different situation. And I should perhaps add that what is very important is the audit rights and how this is going to play out, because you should audit perhaps, you know, your providers, your processors, but companies right now are just so swamped with other work that I'm not sure many have already exercised that, and a lot of companies are resisting that in the contract. So I think that's an area where perhaps a lot should take place.
That's so right, and I think that that might actually be one of the main difference, because from the liability perspective, it's going to be very similar if you read Article 82, but then the audit rights, and also the audit right of a sub-processor and passing this on, let's say the sub-processor would hypothetically be a big cloud provider, then this is really tough to sell. As for enforcement, the only case I'm aware, and I'm happy if someone says no, actually there are 100,000 other cases, would be from Italy. There was a case where the processor actually got a fine, and that was the controller was this political movement, 5-star movement, I think. And then they had a platform, I think the platform was called Rousseau or something, and that platform didn't implement enough security measures and so on. And the platform was actually got the fine, not the controller in this case. Otherwise, I'm only aware that you would go to the top, to the controller, but I don't know, Elizabeth, are you aware of any other cases?
No, not that I can think of right now, but I just want to say that I agree. We, as data protection authorities, we have different tools, perhaps two main groups. We have guidance, the ability to provide guidance, but we also have enforcement, of course. And the GDPR has been applicable for a little more than a year, 1.5 years. And so it is still early days, perhaps. But I think that given time, we will see more case law.
Well, I totally agree with Michaela and Anna here about, I don't think it's the GDPR that made us change guidelines. For many actors, many organizations, and maybe authorities, the GDPR made the organizations discover that there was a difference, actually. And there is a limit between joint control and processor, actually. It's a very interesting legal area. It's a complicated legal landscape. It's good for us to have a conference here, 300 persons thinking about it as experts. But the main problem, I think, actually is the general knowledge, or the general, so to say, ignorance about this fact. The persons involved in contract writing, they don't see this difference between this.
How does it work in your organization then? So who writes the contracts, and how well are they informed?
Well, of course, we have this central organization, so to say, with legal and information experts. But of course, each processor, each controller, each authority signs the contracts, but the processing is made in this center, so to say. But I think the role of the DPO is actually also actually very important. How to get the other lawyers to come in dialogue with the DPO, for instance. That's a very crucial thing.
I think leadership in data protection is a super important topic, and part of that gets spreading the message. Often the people do not report to the DPO directly, but then they kind of have to have some relationship there. At Nokia, we had the idea that it would be basically like you make bread and you have sourdough, that you kind of would put people in the organization, the privacy officers, and then over time the organization kind of becomes privacy infected or goes through. And that's how we have the influence through the offices then, and that I think many have that structure. I mean, when you negotiate contracts on controller processor, let's say you would have either joint controller or controller processor relationship, do you have limitation of liability then, or is that something you never would do?
I almost started laughing at the hours that we've spent in my organization to discuss this. It all comes down to the business case and what kind of contract we're talking about and how to deal with it. And at the end of the day, privacy risk towards the other party is like any other risk. It's part of a business decision. So what we do is we of course we will try to put this in at rather as early on in the negotiation stages as possible, that how valuable is or how dependent, like Anna said before, it can be a small or a big actor, are we of this player, and how do we deal with their demands on liability. But then I think just linking to what we said before, in order to educate ourselves and also making sure that we're doing as good as we can in this area, as soon as we get a precedent such as the fashion idea, it's all about educating ourselves, educating our lawyers, having someone really digging in and understanding this case law and how does it affect us. And then we take that into the negotiations, and we will point back to not only the guidance, but also to case law in order to try to get the right result.
Yeah. And thankfully, more case law is coming. I think we have around 3-minute times for questions of the audience now, and I see a question there, and I'm supposed to kick something in that direction, but maybe someone else could. There's an orange square, and it's coming. Yeah, so for the next one, I can use the green one. And please say your name and where you're from, and then for which organization, and then to whom you would like to address the question.
Well, I'm Lotta Rizzo, and I work at Left is Right. We have a lot of customers that have deals or contracts with how do you say that? The community, the
municipalities.
The municipalities, and many times you see that a law is stating who is the controller. For example, if you're working with social I don't know how to say this in English.
Services?
Social services, a private party doing social services. It states in the law that you are the controller. In the socialtjänstlagen. How do you say
the Social
that?
Security Act.
Yes. And many times I don't see that the actual private company really has any control over data that they put into the systems of the municipalities, was it?
Yeah.
Yes.
Yeah. And your question would be is
my question would be, do you think this is going to change? Do you think that this is going to make the politicians change these laws, or?
I think, Mikael, that sounds like your territory.
Well, I think that the legal, as you told us, Elizabeth, the legal situation is almost the same before and after. But of course, the awareness that I'm talking about is coming now to all organizations, and also by that we can also talk to the politicians, to the government, to make this, because as I said, very often we see that in the system, digital system, maybe 2 state agencies and all the municipalities have the same things to do there. We have built this and constructed this together, and we also have decided on this, the purposes and means together. Of course, we have then to make this arrangement to regulate the joint responsibility, and it should also be very clear to the subject where the responsibility is. So that's we're looking forward to that. It's a big, so to say, not a problem, it's a challenge for the future.
Yeah.
And I think that it's important that everyone is aware of what the aim of defining different roles is. That being a controller is the one who can determine about the processing and make sure, and has the responsibility according to the GDPR to make sure that the processing is in compliance with the law. And in order to do that, you have to be able to exert some real influence on the processing.
Thank you. I think there's one more question. I'm allowed to throw the dice once. Let's see if I hit someone. Oh, actually, I almost did. So, I was actually aiming for the glass. So sorry.
Alexander Hanfier from Think Privacy. So we touched briefly on this imbalance we have with certain joint controllers or service providers, and this is something I see a lot. And we have this, and I very much applaud the Fashion ID case. I think it was a great judgment from the court and the Advocate General's opinion prior to that. But we have a situation, and I see this every single day, where there are certain parties out there, and I don't think we need to mention any names, who have huge power. And they really dictate the terms of that relationship. And there's no means for these smaller companies, or even large companies like Telia in many cases, to do anything to change how that relationship is going to work. Because either they accept those terms, which are in most cases incredibly limiting on these particular parties, or they don't have access to these services, which puts them in a position where they can't compete because there's a monopoly on these services, or a duopoly in some cases. So my question is to Elizabeth, how do we address this issue of, we have joint liability, which is a more balanced and equalizing of responsibility, but we have a complete imbalance of power in many of these sectors that we're talking about with regards to GDPR. How do regulators intend to overcome these hurdles?
I'm afraid I don't have the solution, but of course we're aware of this feature and that this is how things work. What I think the guidance will try to do is to explain that if you have influence on the processing, if you determine the purposes and means, you are a controller, and that's nowhere you can get away from that. But that's the guidance we can give. Then there's another thing, what happens in real life and in enforcement, perhaps.
Well, thank you. That's all we have time for. Hope you enjoyed it.